Good afternoon. Today I've been asked to talk about the topic of East meets West, understanding marriage issues involving Eastern Christians. And I know this is a challenge for many people. I work on a tribunal and in a chancery, and I get a lot of phone calls about ascription questions, about what I call the weird situations, and today we'll try and provide a little bit of guidance, what to do at those times. So in the preamble to his motu proprio de Concordia inter codices, Pope Francis wrote that the Church has a need of better defining relations with the faithful belonging to non-Catholic Eastern churches, who are now present in increasing numbers in Latin territories. Regularizing the relations between the various churches in the Catholic Communion was a modifying factor in modifying 11 articles of the Code of Canon Law in May of 2016. While the influx of Eastern Christians into what the Holy Father calls Latin territories is not a new phenomenon, the continued increasing number presents a pastoral challenge that requires ministers, especially Latin pastors, to be attentive to the needs of Eastern faithful. Providing for the spiritual needs of the Eastern faithful is in fact a requirement in canon law that says, if he, the diocesan bishop, has faithful of a different rite of a diocese, he is to provide for their spiritual needs either through priests or parishes of the same rite or through an episcopal vicar. That's Canon 383, paragraph 2. This requirement is even present upon the entire Christian faithful and those who have frequent dealings with the faithful of other churches sui juris, and we read that they are to have an accurate formation in the knowledge and practice of the rite of the same church. It's Canon 41 of the Eastern Code. Certainly, ensuring the validity of sacraments is a basic element of providing for the spiritual needs of Eastern faithful. Sacraments are, after all, signs of divine grace. They affect the sanctification of humanity. And sacred ministers and other members of the Christian faithful are to use the greatest veneration and necessary diligence in their administration. Canon 840. It is in helping provide this, quote, necessary diligence that this current study embarks in terms of one of the sacraments of the Church, and only one of them, marriage. The complicating factors related to both Eastern Catholics as well as Eastern non-Catholics will be addressed as appropriate. I should mention too that we'll use the phrase Eastern non-Catholic, which is the phrase used in the Eastern Code, for the simple reason that when we're speaking about Eastern non-Catholics, who we usually or commonly would refer to as Orthodox, that we could be referring to Eastern Orthodox, we could be referring to Oriental Orthodox, or we could be referring to the Assyrian Church of the East. So those are the three main families of Eastern non-Catholics. So we'll just use the umbrella term Eastern non-Catholics to describe them all. Before the celebration of the sacrament of marriage, it needs to be determined that, of course, the parties are free to marry, and to marry as the Church intends. That is, nothing stands in way for a valid and licit celebration of the sacrament. And of course, the way this normally occurs is through the completion of the prenuptial inquiry. And if we're a pastor, or if we've ever been married, or perhaps even both for some of our listeners, that we've done these forms where we sit with the couple and go through the different questions to make sure that the right intentions are present and the legal requirements are present. It's this inquiry that aids the pastor, hopefully, in determining the proper ascription of an individual into a specific church sui juris. And this, of course, ensures that the required jurisdiction is present. Marriage is an act of jurisdiction, and the pastor needs to have jurisdiction over the parties, whether by office or by grant of competent authority. The investigation also identifies whether the party is possibly a subject of the Code of Canons of the Eastern Churches, which does at times have varied sacramental discipline, and we'll look at that. So properly determining the ascription of someone into a church sui juris is a key aspect in ensuring the validity of the sacraments. So we want to make sure that we properly ascribe them to their church. Ascription is, of course, determined in line with the norm of law. It is a fact of pastoral ministry that Eastern Catholics themselves are at times even unaware of their ecclesial ascription. They may be completely unaware they are Eastern Catholic. Perhaps they were baptized in a Latin parish. They say they're Roman Catholic. And they've been practicing Catholics in a Latin parish for their entire life. However, as is noted in De Concordia Inter Codices, the practice, however prolonged, of receiving the sacraments according to the rite of another church sui juris does not entail enrollment in that church. That's the new Canon 112, paragraph 2. Additionally, some Eastern churches can be known by different names in different parts of the world, adding to the confusion. For example, if you say Roman Catholic in certain parts of the world, like Syria, that often means what we would call in North America to be a Melkite Greek Catholic. So that can cause some confusion as well. While the pastoral minister needs to be sure to diligently complete the prenuptial investigation, I think that determination of ascription needs to receive special attention, especially when there's reason to believe one or both of the parties could be Eastern Catholic. And sometimes we can just know this because of a last name, where their parents are from, so ethnicity or country of origin. For example, if an Indian couple indicates that their parishes of baptism are in Kerala, India, given the wide presence of Eastern Catholics in this area, we should probably make a proper determination of their ascription beyond the simple question of saying, what rite or what church do you belong to? I find sometimes it's helpful just to Google the parish of baptism or Google where their parents were married, and often you'll find, oh, that's actually a Syro-Malabar or a Syro-Malankar parish, and you know that we need to look a little bit deeper. When the faithful are from the Middle East or parts of Eastern Europe, this is certainly also a good recommended praxis. Ascription, of course, follows the Catholic parents. When only one parent is Catholic, it's the church of the Catholic parent that indicates the ascription of the child, regardless of the place of baptism. It's Canon 111 of the Latin Code. If both parents are Catholic, ascription follows the father, unless the parents agree differently. So sometimes I've had, Latin father, Eastern mother, and the Latin father and the Eastern mother decide, well, we should make a decision how we want to raise the children, how will they fast, what days of obligation will they have, or what we call days of precept in the Eastern Code. And they decide, well, as a family we are going to follow the Latin rite, and the ascription of the children are so determined. If the parents are unwed, ascription follows that of the mother. So even if it is a Latin father and say a Ukrainian mother, if they're not married, then we go through the mother's ascription. If the parents are unknown, ascription follows that of their guardians or adoptive parents. And if the parents are not even baptized, which of course might happen, you might have someone who's quite young who comes to you for baptism. Maybe they have a grandmother who's very interested in their being raised in the Catholic faith, and the parents are a little bit less interested. The ascription follows that of the one who has responsibility for their education in the Christian faith. That's actually Canon 29 of the Eastern Code and is not present in the Latin Code. If the person is 14 years of age or older at the time of baptism, they're able to select their own church of ascription, so they can decide where they want to be baptized, which often will be the place where they are, in fact, being baptized. One who's received into the church from another non-Catholic church is to be ascribed into the corresponding church sui juris. So if you are a Greek Orthodox layperson, you want to become Catholic, hopefully not by being baptized at the Easter Vigil, but by being received into the church as a fully initiated Christian, you would become a member of the Greek Catholic Church sui juris. If you are Ukrainian Orthodox, you would become a member of the Ukrainian Catholic Church sui juris, even if that reception happens, as it often does, in a Latin parish. You still belong to that church sui juris that is, as Father Zuzek would say, who is one of the main sort of architect of the Eastern Code, he would say that it's imprinted almost on you in your mother's womb, this idea of the church sui juris being a part of who you are and something that you need to hold on to. And in fact, canon law says you have an obligation to hold on to. Noting the Church of Ascription in the baptismal register is now a requirement in the Latin Code. And this is certainly a best practice for Eastern Catholics as well, to avoid issues in the future. So that's Canon 535, paragraph 2 of the new Latin Code. So we have the revised norm in De Concordia into the Latin Code. So we would want to make sure, in the remarks, observations, a little often on the right-hand column, ascribe to Ukrainian Catholic Church, ascribe to Maronite Church, or sometimes it might be, I've written in registers, parents have decided to raise child Latin, or whatever ascription options might be possible. And you would just make a little, very short annotation in the register. It might be helpful in the future, if any of you are involved in designing baptismal registers, to have a separate column for ascription, given that it's now a requirement of the universal law. It is also, additionally, possible to transfer ascription. A Latin spouse or an Eastern wife can transfer to the church sui juris of the other spouse at any time after marriage. The children of one who transfers church sui juris can also, in some circumstances, transfer their ascription, following Canon 34 of the Eastern Code and Canon 112 of the Latin Code from De Concordia. These transfers take effect from the moment of declaration before the proper pastor or the ordinary, who we call a hierarch in the Eastern Code, and they are to be noted in the baptismal register. So there should be a notation made that this person transferred their ascription on this day, and if wherever they were baptized, there should be a notification sent to them. Now, the majority of these norms in the Eastern and Latin codes are now harmonized as a result of De Concordia Intercodices, with a few exceptions. For example, the one that I mentioned, where if both parents are unbaptized, that there's no corresponding norm for that in the Latin Code. Now, a question I get very frequently is, what about a Catholic child born to a mixed marriage, a Catholic and say an Orthodox parent, who was then baptized in the non-Catholic church? So Julie is Ukrainian Catholic, Sam is Ukrainian Orthodox, and they baptize their child in the Ukrainian Orthodox Church. Now, it would be my opinion that a strict reading of the canon would indicate that the child still follows the ascription of the Catholic parent, because ascription happens, quote, in virtue of baptism, end quote, ipso iure. Doesn't say the baptism has to be in the Catholic Church, just in virtue of baptism. And canons are, of course, to be interpreted according to the plain meaning of the words. And that interpretation, I think, follows such an understanding. That interpretation, while perhaps not ecumenically sensitive, is further supported by a private reply of the Congregation for the Eastern Churches, which, in the case of a child of a Latin mother and an Eastern Catholic non-father, said the child, quote, was certainly Latin, despite being, quote, wrongfully baptized, quote, in a non-Catholic Eastern church. So that's a Latin mother, Eastern, say Greek father, baptized in the Greek Orthodox Church. The congregation said that child is certainly a Latin Catholic. And that reply is published in Canon Law Digest 3, if you're very curious, from 1952. So after we've determined ascription, we then can have an understanding of, well, is this party Catholic? To which church do they belong? Hopefully we understand that. Hopefully we know that if they are a Maronite or Ukrainian, marrying a Latin, they do not need a dispensation from disparity of cult or permission for mixed marriage, that they are Catholic. But more fundamentally, hopefully at this point, we now understand whether or not they are subjects of the Code of Canons of the Eastern Churches. Because, of course, Canon 1 of both codes says, the Latin Code is for Latin Catholics, for the Latin Church, and the Eastern Code is for the Eastern Churches, and only the Eastern Churches, except when it's obviously not. For example, some canons in the Eastern Code, of course, refer to including the Latin Church, or even the Latin Church, or something similar. So this is an important distinction to which law they are subject that needs to be discerned in order to determine the canonical form of marriage, which is the second thing we're going to talk about. The canonical form for marriage differs significantly between Eastern Catholics and Latin Catholics. The form for the celebration of marriage is articulated in Canon 828 of the Eastern Code that says, paragraph 1, only those marriages are valid that are celebrated with a sacred rite in the presence of the local hierarch, local pastor, or a priest who has been given the faculty of blessing the marriage by either of them, and at least 2 witnesses, according, however, to the prescription of the following canons, without prejudice to the exceptions referred to in Canons 832 and 834. Paragraph 2, the very intervention of a priest who assists and blesses is regarded as a sacred rite for the present purpose. So we're going to exegete the canon and talk about what exactly is required here. And there are several aspects to the canon. First, the fact of the requirement of the intervention of a priest is an obvious distinction when one compares the canon to that of the Latin Church. In the Latin Church, of course, one could be married by a deacon, or perhaps even by a designated layperson in some circumstances. Some canonists had even argued that a Latin deacon could be delegated to receive the consent of the Eastern Catholic faithful. The idea being that the law of the place rules the action. And so some well-known canonists, for example, Victor Pospisil says this in his Eastern Catholic Church Law. Personally, I didn't agree with that opinion, and thankfully the Holy Father sided with the other argument and says that it's clearly not permissible. If one or both of the parties are Eastern, whether Catholic or non-Catholic, the marriage is to be celebrated by a priest. And that's Canon 1108, paragraph 3 from De Concordia. This canon requires the marriage to be celebrated with a sacred rite. And that sacred rite is defined as the blessing of a priest. So it's not simply the presence of a priest at a wedding that is a necessary requirement for marriage, but the priest must celebrate the marriage by imparting the priestly blessing. Now, what about the case of 2 Orthodox Christians who attempt civil marriage at a restaurant? The Eastern Code indicates that the minimal form of marriage recognized by the Church for the marriage of Eastern non-Catholics is celebration of marriage with a sacred rite. And that's Canon 781, number 2 of the Eastern Code. Now, if they married at a restaurant, the question is whether or not they had the sacred rite, that is, the blessing of the priest, present. If the sacred rite was absent, the marriage lacks canonical form. But what if the wedding at the restaurant was conducted by an Orthodox priest? Perhaps he's 6 kids, needs to get them through college, and he's moonlighting as a civil marriage register. Now, in such a case, we would need to determine as to whether the priest made use of a sacred rite. And if it could be established that the celebrant married them simply according to civil rites, I take you, something similar, without any sacred rite, this was not a Christian service following the books of the Orthodox Church. This was just a person who happened to be an Orthodox priest, but could have been Church of Buffy the Vampire Slayer or something similar, who just happened to be at the restaurant receiving their consent. And in that case, we would have, if the priest did not use a sacred rite, we would have, I think, a defect of form, maybe rather than a lack of form, given we had a priest present. So the presence of the priest is a necessary but not a sufficient factor. We need to have the priest who then imparts the blessing, that is the sacred rite. Now, this integral requirement of having the blessing of a priest has several logical conclusions that result in other parts of legislation in the Eastern Code. First, marriage by proxy can be prohibited for Eastern Christians or Eastern Catholics in the particular law of a church sui juris. And this, of course, is a logical conclusion. If you need to receive the blessing of the priest, stands that perhaps we would need to have physical proximity to the minister in order to receive it. The necessity of receiving the priestly blessing further results in the prohibition of granting an Eastern Catholic a dispensation to canonical form. So if we look at Canon 835 of the Eastern Code, it says that a dispensation for canonical form is reserved to the Patriarch or to the Apostolic See of Rome. The diocesan bishop, the eparchial bishop, cannot grant a dispensation from form to his faithful in in North America, for example, without having recourse to the Apostolic See. And this, of course, again, is a natural conclusion, because dispensing from form would be dispensing from that integral requirement of having a priestly blessing. And this is seen as being integral to marriage for Eastern Christians. So Latin ordinaries who have Eastern faithful, of course, the law doesn't address this. The law on dispensations from form, which is the law binding the ordinary, says he can do this. There's nothing in here saying that people can't receive it. It deals with the person granting the permission, the dispensation. So really, we would think, though, that the Latin ordinary probably, it would not be prudent, I think, to grant the dispensation, just given the sacramental reality that is present for those Eastern Christians. Additionally, the canonical form requires marriage to happen before a designated minister. That is, the person needs to have jurisdiction over the parties. That's a key part of canonical form. And this reemphasizes the importance of properly determining ascription of the Catholic parties. So if two Eastern Catholics that have been attending a Latin parish since birth, perhaps were even baptized there, marry before a Latin pastor who knows them, well, I know them, I don't need to do the interview, and doesn't realize that, say, they're both Maronite Catholics, he lacks jurisdiction, and the marriage would suffer from a defect of form. The celebrating priest needs to request the faculty granted by the local hierarch or the proper pastor of the parties. Now, supposedly, quote, solving the problem by encouraging the parties to transfer to the Latin Church is a practice that should never occur. And in fact, if we look at Canon 1465 of the Eastern Code, that's actually a delict. Inducing someone to transfer churches sua juris is a delict. I've heard of this happening also sometimes because the deacon's daughter is marrying an Eastern guy, and he would really like to marry his daughter, and he can't do that. So, well, why can't he just transfer to the Latin rite? Maybe he's not even practicing Catholic or something like that. And that's actually a delict, so he can't do that. Now, what about when two Eastern non-Catholic faithful present themselves for marriage at a Catholic parish? Now, this marriage can proceed under certain circumstances. So, two Greek faithful freely present themselves at a Catholic parish for marriage. If nothing stands in the way of the licit celebration, the priest can be granted the faculty to perform the marriage by the local hierarch. Now, for an Eastern Catholic minister, the Eastern Code requires that minister to additionally determine the parties are unable to approach their own minister without grave difficulty. That's Canon 833. And while the Eastern priest is bound to inform, if possible, the proper authority of the non-Catholic parties prior to the celebration of marriage, a Latin pastor in the same situation only has the requirement if it is prudent. So that's Canon 833 of the Eastern Code versus Canon 1116 of the Latin Code from De Concordia. Of course, we could see that maybe letting the Orthodox bishop know before the celebration of marriage that you, as a Catholic priest, are going to marry these two faithful might cause some issues. And so the legislator in the revision from De Concordia has said, well, if this is prudent, because of course, in many times it might cause the couple problems and we might not want to do that. Now, what about when a Catholic marries in the Orthodox Church? If a Latin or an Eastern Catholic marries an Orthodox Christian in front of an Orthodox priest, the form for marriage, as we know, is simply for liceity. That's Canon 1127 of the Latin Code and 834 of the Eastern Code. So that is, a Catholic party who marries, a Greek Orthodox individual without any necessary permissions still marries with presumed validity in the Orthodox Church, just as if they married the same way in a Catholic church. The simple fact of their marrying outside the Catholic Church should never be assumed as resulting in a lack of form case. And unfortunately, this one trips up pastors a lot. Because they know, well, you didn't get married in the Catholic Church. And if you get married at the Anglican Church, that doesn't count. But of course, if you get married at the Orthodox Church, it counts. And Father then realizes that he has a wedding scheduled for a month from now, and the people are not free to marry. We should, of course, also make sure the parties are not engaging in multiple exchanges of consent. While this would not be an expected situation with an Eastern Catholic marrying a Latin Catholic, of course, we probably would have one Catholic marriage. If a Catholic marries, say, a Russian Orthodox in the morning in the Catholic parish, and then engages in a second marriage in the afternoon at the Russian Orthodox Church, we have an obvious issue. And this can become more complicated. For example, if the marriage is then later challenged for invalidity before an ecclesiastical tribunal. Because, of course, if we prove the invalidity at the morning exchange of consent at the Catholic parish, the Orthodox parish, the exchange of consent there becomes presumably valid because they would have, albeit illicitly, validated the consent. Care should be taken that the sacraments are also not repeated by an active reception by a Catholic into an Eastern non-Catholic church. And sometimes this happens, our people aren't aware, they maybe even go through the paperwork. I want to get married to the Coptic church, so they go to their pastor who says, well, we can do this, and the permission is granted. And they go there, and the Coptic priest says, okay, we're going to do the wedding, but before, we just need to chrismate you, or we need to anoint you. And the person says, okay, well, that sounds fine enough to me. It's very possible in certain jurisdictions, and perhaps in some jurisdictions, especially Oriental Orthodox jurisdictions, it's very likely for this to happen, that chrismation or confirmation would be administered to the parties as an act of reception from schism or heresy. It should be noted as an aside that in the Catholic Church, East and West in the Catholic Church, we have the idea that confirmation or chrismation is not repeated. In the non-Catholic East, it is repeated, and that's in fact from the ecumenical councils. And that if someone went into schism, for example, became an Arian or an Apollinarian in the period of the early churches, if we look at the Council of Nicaea, for example, they would be received back into the church, not by baptism, of course, but by chrismation. So this is a practice that's still done in many Orthodox churches. Catholic parties should be aware of what's happening, and if it's suggested that, hey, we're going to just anoint you, or perhaps even in some circumstances we're going to baptize you, that this is not a liturgical action suitable for a fully initiated member of the church. Now, what about the case of two Catholics who marry in an Orthodox church before an Eastern non-Catholic minister? Latin Catholic, for whatever reason, they can't get married in the Latin parish, or they good friends with the Orthodox Church pastor, and they go down there for marriage. What about that? Does that satisfy the canonical form for marriage? Personally, I think the answer to that question is in the negative. That is, it does not satisfy the canonical form. The canons clearly prescribe the form for marriage as being before the hierarch or ordinary, pastor, or other designated minister, depending on their ascription. This norm for validity is subjective to an exhaustive list of exceptions that are, namely, the extraordinary form of marriage when impeded from accessing a minister, marriage with an Orthodox Christian before an Orthodox priest, and that's not the situation here, and marriage with a dispensation from canonical forms. We have three exceptions to the requirements of form. Catholics are bound to the validity of their union, to canonical form for the validity of their union, and marriage to an Orthodox church between two Catholics before an Orthodox priest does not conform to either the canonical form of marriage or the three exceptions provided for in the law. So therefore, it would seem to be a very clear conclusion that two Catholics attempting marriage before an Orthodox priest in the Orthodox Church do so invalidly. That is, there is a defect of form present. Now, what about the capacity of the parties for marriage? Because there are, in the common law, some differences between the Eastern Code and the Latin Code in terms of the person being capable of contracting marriage. And again, if we don't determine the ascription properly, which is that thing we need to do very clearly, we cannot properly determine to which rules the person is subject. An improper determination of ascription can sometimes have invalidating effects in some circumstances. When, for example, someone is believed to be a subject of the Latin Church, but is instead subject to the different matrimonial norms of the Code of Canons of the Eastern Churches. And the first of these would be impediments. The Eastern Code includes additional impediments in the common law. So in the Eastern Code, hopefully we own an Eastern Code, or at least have it bookmarked online. We've maybe cracked the spine once or twice, taken the wrapping off at least. We know that there's a thing called the common law, which is that law common to all the Eastern churches. And then we have the particular law of a church sui juris. So, there are norms that bind all Eastern Catholics in this book, and then the Ukrainian Catholic Church, the Maronite Catholic Church, the Syro-Malabar Catholic Church, all have the obligation of issuing their own particular law that is approved by their own church's highest authority, that reflects the principle of subsidiarity in a way that's not present in the Latin Code, that each church sui juris is able to make suitable determinations, for example, about the Eucharistic bread, fasting requirements, days of obligation, and also whether there are any additional diriment impediments. The particular law of a church sui juris can establish additional diriment impediments. This requires consultation with the Apostolic See of Rome, but it is possible. Before establishing such a diriment impediment, the church sui juris is required by the law to consult the neighboring bishops of a region. That's in Canon 792 of the Eastern Code. Now, this would hopefully bring out any resistance that other bishops and a region might have. Perhaps they would like to have the same impediment. It would be strange if, you can't do this in that church, but you can in this church when you live across the road from each other. But it also would have the practical reality of informing the other bishops that this is now an issue, and they would know that, well, for faithful of this church sui juris, be aware that this impediment exists. So then we have some other impediments contained within the common law that are not present in the Code of Canon Law. And the first of those is affinity in the collateral line. Now, in the direct line, for both Eastern and Latin Catholics, affinity invalidates a marriage. This prevents, for example, a man marrying his mother-in-law if he somehow became free to marry. Well, both of them would be free to marry. However, while Latin Catholics are not impeded in the collateral line, Eastern Catholics are impeded to the second degree. And this means that a man cannot marry his sister-in-law. An Eastern man cannot marry his sister-in-law, without a dispensation at least. And this is reflecting the idea that marriage brings families together, and as a result, there are some degrees of kinship that are forbidden. Now, while marriages in close degrees of kinship might seem strange to us in the West, they are a fact of life for many cultures that are minorities, Christian minorities in their homelands. Amongst the faithful of certain churches sui juris, for example, in predominantly Muslim countries, it might be extremely common to marry your first cousin, or to marry an in-law, or some other degree of kinship. And chanceries need to be aware of these practices, because even sometimes the person's living here, but the marriage is arranged by their parents in Syria, in Iraq. They even might travel back to get a spouse from those homelands. And if these aren't done properly, then of course we have a problem. The second diriment impediment present in the Eastern Code that's absent from the Latin Code of Canon Law, at least in the revised 1983 edition, is spiritual relationship. And this impediment prevents a marriage between a baptismal sponsor, the person baptized, as well as the baptized person's parents. And this impediment arises to Eastern Catholics of any church sui juris. So, as described earlier, ascription is determined by law and not by baptism. So we could have a Ukrainian male who has been raised his entire life at the Latin parish. He's been attending it since infancy. Now, he meets this lovely lady. The trick is she's not baptized. And, well, pastor thinks this, well, wouldn't it be romantic if you sponsored your beloved to become a Catholic? And that the Muslim girl is then baptized and becomes a Latin Catholic, assuming she's over 14 and her parents aren't baptized and all these kinds of things. She becomes a Latin Catholic. Now, while she is free to marry him, The problem is that he is now impeded by spiritual relationship because he is an Eastern Catholic. Even though Father doesn't realize that, he's an Eastern Catholic. He has this impediment in virtue of being a subject of the Code of Canons of the Eastern Churches, and that impediment needs to be dispensed in order for him to marry validly. And so again, we can see the importance of properly determining ascription. There also is some difference in the canons on matrimonial consent. Some of these are just differences in language. But there also is the idea of conditional consent is very different in the Eastern Code. In Latin canon law, as we know, future conditions are not allowed. They are invalidating, but they are not allowed in any form for Eastern Catholics. A Ukrainian Catholic man or a Maronite Catholic woman cannot establish marriage with a present or a past condition. That's not possible, where that is possible for a Latin Catholic man or woman. So Canon 1102 of the Latin Code, of course, is the corresponding legislation. And then Canon 825 of the Eastern Code says marriage based on a condition cannot be validly celebrated. They are not able to place conditions on their marriage, and as subjects of the law, that doesn't really matter where they are celebrating it. So Latin pastors should be mindful of this requirement. And in fact, since each party is bound to the law by which they are subject, it is possible that a marriage could be subjected to a condition by one of the parties. For example, Latin bride, Eastern groom, the Latin bride could subject the marriage to a condition. She's allowed to do so by her law, whereas the Eastern party, if he did that exact same condition, it would invalidate the union. So you have one bond that has two different subjects of law, two different bodies of law governing it, and some things are possible for the one and not the other, which can definitely be a confusing aspect of the law. So we can see how the Eastern Code and the need to properly determine ascription is really important. It really is necessary for validity to make sure whether these are true sacraments. Can a young man marry his sister-in-law? Can someone sponsor their fiancé for baptism? Is marriage subject to a condition even possible? And the answer to these questions depends on whether the individual is subject to the prescriptions of the Eastern Code, that is, whether or not they are an Eastern Catholic. Determining this issue correctly ensures not only the valid and licit celebration of the sacraments, but beyond that, ensures the parties are able to enter into marriage in accord with their rights in canon law. So for example, if I'm a Latin person marrying an Eastern person, and as a Latin person, I have the right to impose a condition upon my marriage, right? That's afforded to me in the law. And so I should be entitled to do so, and not if I'm marrying an Eastern guy, a guy marrying an Eastern girl in an Eastern parish, the father says, well, you can't have marriage by condition. Well, no, the Eastern party can't have marriage by condition. The Latin party is afforded that in canon law. Now, finally, I want to talk about some things that precede the celebration of marriage. We might call this things that Father Alex sees a lot. Some of the common questions or common mistakes, unfortunately, that I see working in a tribunal and working in a chancery. I think that there are certain pastoral concerns that should be on the mind of pastors and other ministers in ensuring the parties are suitably prepared and free to enter into a marriage in the Catholic Church. So while the migration of Eastern Christians into the so-called diaspora is not a new phenomenon and has been going, in North America at least, for over a century, there are definitely regions in this same continent, in North America, that have little exposure to Eastern Christians, who have often restricted themselves to concentrated areas, especially urban areas of certain countries. So while we might have a lot of Ukrainian Catholics in Toronto, we might have a lot of Melkite Greek Catholics in Montreal, or a lot of Ukrainian Catholics in rural Canada, we would have a great number fewer of Ukrainian Catholics in Fargo, North Dakota. We would have a great number fewer Chaldean Catholics in Seattle, Washington, and just the way that migration has gone. And so we have some local churches that just have less exposure to this. And it's now becoming more of an issue with the continued migration of people. The fact we don't have a grandfather clause in ascription, which might be a smart thing in the future, right? So if you can go back far enough, you might be able to demonstrate they're actually Eastern Catholics, which gets a little bit tricky sometimes. And even parishes today are often responding the call of charity, of the gospel of charity, and sponsoring refugees from the Middle East. And of course, if they are Christian, they are most likely not Latin Christians. They are often Eastern Christians, and they might be settled in the small rural diocese in northern Ontario, and has no experience of Eastern Christianity. And Father now has these, Chaldean faithful in his parish that he needs to decide, well, how can I effectively minister to them? So I think we need to have some discussion about Eastern non-Catholic faithful approaching marriage in a Catholic church with a letter from their own ecclesial authority indicating freedom to marry from a prior bond. So, we have a nice Italian girl. She's met this Serbian Orthodox guy. He's divorced, but he says, hey, but it's okay. Look, I got an annulment already. And you look at it and it's all, squiggly Cyrillic, but you can figure out with Google Translate what's going on there. What does that mean? And unfortunately, sometimes Father gets that piece of paper and, oh, great, well, we don't have to bother the tribunal then, and gives them a date, and onwards we go. Now, first, we need to note that there is a diversity of Orthodox understandings regarding the indissolubility of marriage. And the churches of the East have, since apostolic times, admitted ecclesiastical divorces for a variety of grounds. The legislation of the early church in the East, if we look at the canons of St. Basil or other canons, adopted much of the Byzantine Roman civil law that was in place at the time. There is not a firm adherence to the indissolubility of marriage that exists in the Catholic Church. And so there might be grounds in different churches, well, there are grounds in different churches, non-Catholic churches, for divorce. So this could include adultery, this could include witchcraft, it could include schism, entering a monastery, attempting to kill the emperor, different things, trying to poison your spouse, conjugicide, actually dissolving the bond, though, which is something very different than what we say exists in the Catholic Church. Different than how the Catholic Church says marriage exists, right? That's what we say. We say that this is how the Creator has established marriage. And I would say most Orthodox Christians see it as being permanent, but not indissoluble, which is not the same thing. And so the practice of Eastern, non-Catholic Eastern churches in this topic is diverse. Some grant ecclesiastical divorces. And then there are a small number of churches that grant processes more closely resembling what we would call a declaration of nullity, perhaps a defective form case, something similar. And so in 2012, there actually was an explanatory note issued by the Pontifical Council for Legislative Texts. It's published in Comunicaciones number 44 from 2012, or you can find an English translation of it in the Jurist number 75, 2015. In discussing these declarations, the Pontifical Council makes the following important observation. Quote, first, it should be noted that very few non-Catholic Eastern churches have norms providing for the nullity of marriage. The majority of these churches have instead a discipline that cannot be reconciled with the doctrine of the Catholic Church on the indissolubility of marriage. End quote. Pastors must clearly understand that a member of the Eastern non-Catholic faithful who indicates he, quote, already has an annulment, likely in fact has an ecclesiastical divorce, which is something very different. The Pontifical Council's explanatory note provided norms for the resolution of these cases, and in all situations where the Eastern non-Catholic party was previously married, the Orthodox party, quote, must obtain from a Catholic ecclesiastical tribunal the declaration of nullity of the previous marriage, even if the nullity of the previous marriage seems to be certain, end quote. So even if this is so obvious that this is an invalid marriage, it's slam dunk, maybe they didn't even live together, whatever, it's an immigration marriage, you still need to go through the norms that are present in the law of the church. So it is clear that all cases of a divorced Orthodox faithful need to be sent to a competent Catholic ecclesiastical tribunal before they can be admitted to marriage in the Catholic Church. Now, if they already received this ecclesiastical declaration of freedom to marry from their non-Catholic hierarch, it's possible that such can, quote, be verified through a canonical judicial procedure to ensure that divine law was not violated. So the appellate tribunal can take this decision and ratify it, basically. The court of second instance can confirm it by decree or by ordinary examination. Now, these norms are from before Mitis and probably should be updated to reflect some of the new procedural laws for the appellate court. But the basic idea is there needs to be an act of reception of that Orthodox decision by a Catholic hierarchical authority. And that's if their Eastern Church actually grants annulments, which is a very few number of cases. What is more likely is it's an ecclesiastical divorce, and in those cases, they have to begin the process anew. They need to start the process for declaring a declaration of nullity. This can be a difficult decision to communicate to the faithful. I've had Coptic faithful who have spent a lot of money and waited a lot of time for their declaration of nullity. Some bishops are very strict on the penance required to grant these things. And then to be told, well, now you need to go through it in the Catholic Church can be a difficult decision for them to hear. Another issue that can arise during the prematrimonial preparation is Eastern non-Catholic resistance to the cauciones. So of course, when we have a mixed marriage, the Catholic party has to sincerely promise to baptize and raise the children in the Catholic faith to the best of their ability, and the non-Catholic party is to be informed about this promise. That's Canon 1125 of the Latin Code, Canon 814 of the Eastern Code. Now, it certainly has been known to happen that the Eastern non-Catholic party, who maybe is agreeing to marry in the Catholic Church because it's the bride's church, you can see how important it is, but these kids are going to be raised Orthodox, or these kids are going to be raised Assyrian, or whatever it might be. And this offers a real pastoral challenge for the minister, who needs to be sensitive to the concerns of the non-Catholic party, while at the same time clearly articulating the requirements of the Church. Now, the canon does say that the non-Catholic party is to be informed at an appropriate time. And I think a lot of this is determining what exactly is an appropriate time to effectively communicate this decision. Finally, pastors should be mindful of their canonical requirement to ensure that non-Catholic parties are aware of the essential ends and properties of marriage. It's Canon 1125, number 3 of the Latin Code, or 814, number 3 of the Eastern Code. So, with respect to Eastern non-Catholic faithful, I think two topics should be especially addressed: the bonum sacramenti, the indissolubility of marriage, and the bonum prolis, the good of procreativity. As has been mentioned previously, there is a diversity of understanding regarding the indissolubility of marriage present within the non-Catholic Christian East. And it's important for the minister to ensure the Eastern non-Catholic party is aware of what the Church teaches, what the Church says marriage is. And that the grounds of divorce present in Orthodoxy, such as adultery, are not admissible for this marriage. That is not going to happen. And can you agree to that? There also is a diversity of opinions amongst Eastern non-Catholic churches regarding the admissibility of artificial forms of contraception. And of course, some forms of contraception do directly impact the jus in corpus, the handing over of rights, which is an integral part of the bonum prolis. And if, of course, an Orthodox member of the faithful who felt that this was a moral illicit thing to do, despite the contrary, then we could have a problem in terms of their consent. You know, that this is a decision that has to be made mutually between the parties, and to recognize the teaching of the Creator on such the topic. This is a challenge, I think, in ministering to Eastern non-Catholic faithful. I mean, it's a challenge dealing with Catholic faithful, but then to communicate this to Orthodox faithful can be very difficult. And hopefully they're going to get some of this in a marriage prep course, but certainly we should not outsource all of that. So Pope Francis notes in De Concordia Inter Codices that the migration of peoples into, quote, Latin regions, end quote, has resulted in not a few pastoral and juridical questions. Now, the Holy Father attempts to identify some and answer some of those in De Concordia. And in this paper, I've attempted to discuss some of those that I see crossing my desk, these juridical pastoral questions, as an aid to those who face such issues. I don't think this is an exhaustive list of issues, just simply those that I see happening and those that directly impinge the validity of the sacrament. And beyond that, we have to remember that marriage is just one of the 7 sacraments of the Church. And we could probably have a similar discussion on every one of these 7 sacraments. And beyond that, on the overall question of the pastoral care of Eastern faithful by Latin pastors. And there are a number of works, especially in Italian, that have been written on this topic. If you're interested, you could probably find them. Some, I know one actually is going to be soon to be republished in a new edition by the Canon Law Society of America that is about Latin faithful with Eastern pastors. So Eastern faithful Latin pastors. And just something to be aware of, that there are resources out there that hopefully your chancery has, your tribunal library has, or even if you're a pastor who has these challenges, these might be great resources to have in your library. I want to thank you for your time. We are not able to take questions given the format we need to use. So if you did have something that was really tripping you up, I always say, don't be afraid to ask. I go out to so many meetings as part of my office as judicial vicar for the simple reason that the priests know me and aren't afraid to call me or email me. And so if you do have questions, now realizing with fear and trepidation, this is on YouTube, so who knows who will email me, but that feel free to send me an email and I'll try and help you out. And it's just my name, Laschuk @archtoronto.org. Thanks a lot.